Welcome to week 2 of the Supreme Court November Thunderdome. We have 2 cases today about liability of detention centers, one criminal, one civil, and Justice Alito will demonstrate his famous pile driver move on Justice Gorsuch, if he can catch him. That little guy's squirrely. Happy Monday, everybody. I'm Brino, and this is the Morning Report on the federal courts for November 10th, 2025. You know the drill. Double tap your screen, like, subscribe, comment whether Barrett or Kagan wore the crown of bones better at last week's match, and watch First Minute right now, even if you're going to come back, so we hit the FYP. I will be going live at 10 with oral arguments. You can watch now or watch them on the tubes later, but I'll give you a rundown on what to watch for in the hearings in just a minute. Check the link in my bio for my wish list and other ways to support me if you'd like, and hold on to your coffee mugs, because Monday is coming. All right, first, government shutdown. All right, I've updated you several times on the court stuff that's happening related to SNAP benefits and all that, but what about the Truth Social posts and what's going on in the Senate? Unfortunately, that is all politics. Not law, not really even policy. It's just not in my wheelhouse. I don't have a nicer way of saying this at this point. This is all just peacock showing off. There's a lot of creators out there who will tell you what the peacock feathers mean. It's just not really my area. As soon as the law changes, I will let you know. But for right now, we are dealing with pure narrative, just trying to convince people to agree with one side or the other. Just not what I do. So let's stick to what I do. Okay. I think this is a bit of a fun one, but only because I think this was kind of a crappy move in the first place. So a bunch of Department of Education employees were sent home. They were on administrative leave. I think they were furloughed, whatever. And while they were out, they sent out of office messages on their email. Sorry, I'm out of the office, whatever, which they then lost access to. Their email access was shut off. Well, funny thing, on October 1st, a chief of staff at DOE overrode all of those out of office messages and replaced them with one that said, Democratic senators are blocking passage of H.R. 5371 in the Senate, which has led to a lapse in appropriations. Due to the lapse in appropriations, I am currently in furlough status. I will respond to emails once government functions resume. Well, on Friday, a judge in D.C. ruled that the Department of Education unlawfully modified its employees' out-of-office message to include partisan language without their knowledge or consent in violation of the First Amendment. Quote, when government employees enter public service, they do not sign away their First Amendment rights, and they certainly do not sign up to be a billboard for any given administration's partisan view, end quote. So the DOE is ordered to fix this problem within 2 days and must file a status report by Wednesday to update the court on its progress. So, okay. Our first Supreme Court case today is Landor v. Louisiana, Department of Correction. So we're going to start with a quick overview of the story. Damon Landor is a devout Rastafarian, and for about 20 years he has kept the Nazirite vow, which requires him to, among other things, let the locks of the head grow long. That is from the book of Numbers, chapter 5, in case you're wondering. And so he did. For 20 years, he let his hair grow. Well, in 2020, Mr. Landor was sentenced to 5 months in jail in Louisiana, and he stayed most of that time in 2 facilities with no problems. In fact, the second facility voluntarily amended its grooming policy so that Landor could keep his dreads. It was an absolute non-issue. And then 3 weeks before his release, he was transferred to one more time to Raymond Laborde Correctional Center. Now, he was expecting a problem, he knew the rules, and he knew when he was walking in, they were going to ask him immediately about his hair. So he walked in prepared. He had proof of his past religious accommodations and a copy of the Fifth Circuit decision in Ware v. Louisiana, which specifically held that cutting a Rastafarian's hair violated the Religious Land Use and Institutional Persons Act. But the guard threw those papers in the trash, called the warden, and when Landor could not immediately meet their demand for a direct order from a sentencing judge allowing him to keep his hair, they carried him to another room, handcuffed him to a chair, and shaved his head. And so the question before the court today, under that same law I cited a minute ago, the Religious Land Use and Institutionalized Person Act, is whether Damon Landor can directly sue government officials for damages in this case. Because according to prison officials, the law in question here does not provide a private right of action for violation. In other words, you can't sue the people who did this. Now, the Fifth Circuit had made another ruling that was very similar to this in a different case, but it was close enough to this one that they felt that their hands were tied as a result. They said, we emphatically condemn Mr. Landor's treatment, but basically we are stuck with the decision we made in this other case. But the Fifth Circuit can be overruled by the Supreme Court, and I would really be surprised if that's not what they're going to do today. This is a very pro-religious freedom court. It's a very sympathetic set of circumstances, and for once, it's not all about protecting Christianity from the ravages of the modern world. So we'll see how this plays out, but I have a feeling the court will be open to this case. Okay, next up is Geo Group v. Mendocal, and I've talked about another Geo Group case in the last couple of months with almost identical facts, in case this sounds familiar. So Geo Group runs a for-profit detention center, or a bunch of them, for immigration detainees, not criminal detention centers. Many of these people will be released once it's determined that they've done nothing wrong. These are just temporary holding facilities. And Geo Group has two programs in place for its special guests. One, it has a required program where detainees must perform basic maintenance stuff. This includes some basic cleaning, not just of their own space, but of the rest of the facilities. And if they refuse, they may be punished up to and including solitary confinement, potentially for up to a week. And two, they have a voluntary work program where detainees are allowed to work up to 8 hours a day, operating the facility, cooking, running the laundry, etc., for $1 in payment per day. Keep in mind, though, the Geo Group is paid by the federal government to operate this place and is paid enough to hire the required number of employees to operate the facility at a normal wage. So if they expected to have, let's say, 20 people working 40 hours a week to run the place, that would be about $12,000 a week. That is baked into their contract price. So the delta, the difference between what they've been allotted by the government and what they're actually paying their workers, which is $1 per worker per day, goes right into Geo Group's pocket. So in August, the Washington State Supreme Court affirmed a case with a nearly identical fact pattern. Different case, though, essentially saying that Geo Group owes millions in back pay to its detainees to compensate them the difference between $1 per day and the Washington state minimum wage. Well, now, Mr. Mendocal is suing Geo Group for forced labor at its Colorado facility, as well as something called unjust enrichment, which means basically they've been collecting someone else's money, namely his and the other detainees whose money they've been pocketing. The problem here is something called sovereign immunity. And we talked about this last week in that Hensley case about whether a military contractor could be sued in civil court. Because under sovereign immunity, you can't sue the federal government for damages unless the federal government consents, which it actually does in a lot of cases. There's a whole federal tort law where they list a ton of examples where they essentially consent to being sued. But the Geo Group isn't part of the federal government. They just, like that military contractor, they just want immunity to cover them too. So they're asserting something called derivative sovereign immunity, which means the government told them to do it. They did what the government said, and therefore they should get the same immunity. So there's a few things we'll be discussing in court today. I want to give you some stuff to be listening for. I'm going to start with Yarsley. I think that's how it's pronounced. Could be Yearsley. I'm not sure. Yarsley is the case that defines derivative sovereign immunity. It has a two-part test. Okay. 1, did the government legally confer authority to the contractor? And 2, did the contractor follow the specific instructions of the government? So two-part test. But Mr. Mendocal, the plaintiff here, is throwing a wrench into this whole machine because Mendocal doesn't think Yarsley creates an immunity at all. The two-part test is fine, but it doesn't give the contractor immunity, he says. It gives them a defense. Okay, defense, immunity, what's the difference? Well, keep your ears open for this because this may be a really big part of the discussion. Here's the basic idea. If contractors are immune from a lawsuit, then you can't bring the lawsuit to begin with. You show up in court and the court says, nope, we can't even start this lawsuit. These guys are immune. If it's a defense, that means the court can hear the lawsuit, and if the court finds that they are liable, then the defense may excuse their liability. It's like, yeah, they did it, but you can't get any money anyway. We will still hear the whole case, though, and decide the defense part last, after we've decided they screw up. And Geo Group does not want a court case. That's a big thing here. They don't want to turn over discovery or get bad press and have a court say they were actually liable. They want this over with. So we have two questions so far. Did they meet Yarsley? And does the Yarsley test mean immunity or defense? Because that's a big deal. Particularly because Mr. Mendocal said, and the lower court agreed, Geo Group's two programs, mandatory sanitation, voluntary work program, weren't entirely the government's idea. Geo Group sort of built on what the government suggested. So it may not meet the second prong of the test anyway. So Geo Group's attempt to get this kicked out because they were immune has failed repeatedly, but there's one more thing you're going to hear. It's complicated, it confuses me a little bit, but it's definitely going to be there, so listen up for this. Collateral order doctrine. Stick with me for one more second. Basically, the Court of Appeals doesn't usually hear an appeal from the lower court until the lower court issues something final, something with a bookend on it. So in this case, Geo Group had its motion for summary judgment denied, which only means that the case is not over. It's far from a bookend, right? It just means the case keeps going, so there's no appeal. Usually you appeal that at the end of the case. But Geo Group doesn't want a case. They want this stopped now. So they argued that in this case, the denial of summary judgment based on their immunity was a collateral order, which means it's close enough to a bookend to allow for an appeal right now. That's the best I can do with collateral order for right now. So listen for these four things: derivative sovereign immunity, two prongs of the Yarsley test or Yearsley, immunity versus defense, and collateral order doctrine, and you should be ready. All right, that is your Monday morning report on the weekend in federal courts and today at the Supreme Court. Stay tuned for oral arguments live at 10 a.m. Check in on my wish list or the link in my bio to help me stay sustainable, and keep watching, everybody, and I will keep going. Thanks a lot. Have a great Monday.